Hello, everyone. Welcome to week 6. This week, we're going to talk about legislative scope and purpose. And in terms of the key outcomes, after studying this topic, you should be able to discuss and explain the three key rules that a decision maker must observe in making a decision or in exercising a statutory power. And in particular, these three rules are the following. Number one, a decision maker must exercise a statutory power according to the purpose for which it was conferred. Secondly, in exercising a statutory power, a decision maker must not take into account irrelevant considerations. And thirdly, in exercising a statutory power, a decision maker must take relevant matters into account. So, having discussed the rules for decision making, we should then be able to cover all those in detail in the course of this lecture podcast. And we must remember that these rules for decision making actually provide the scope and the limits of executive decision making in administrative law. So let's begin by looking at that notion that an administrative decision maker must act only for an authorized purpose. So in other words, he should not be acting for an unauthorized purpose or a purpose that is not authorized by the statute. So as a rule, a person or body exercising a statutory power, in other words, a power that is conferred by statute, must exercise that power only according to the purpose for which it was conferred. In other words, if an executive decision maker exercises a power for a different purpose or for an improper purpose or for an ulterior purpose, then the exercise of such a power would be illegal and invalid. And this was clearly a principle that was decided upon and established in the case of Brownells Limited versus Ironmongers Wages Board, where Chief Justice Latham said, where a statute confers powers upon an officer or a statutory body, and either by express provision or by reason of the general character of the statute, it appears that the powers were intended to be exercised only for a particular purpose, then the exercise of the power not for such a purpose but for some other ulterior motive or object will be invalid. In this particular case of Brownells Limited versus Ironmongers Wages Board, the board had been authorized to determine and fix the wages of those working in the ironmongers industry. I'm not even sure if a lot of you have heard, that notion of ironmongers. And I was looking into it, and it would seem that ironmongers refers to hardware stores. So this was a time when you'd see a lot of hardware stores. I'm not exactly sure if you'd see a lot of that in Australia, because you'd probably end up going to Bunnings, and it's more than just a hardware store. Because an ironmonger is essentially an object or a tool that has metal. So if you look for nails or GI sheets, you'd probably go to an ironmonger or a hardware. Well, at any rate, apart from that background, so as I pointed out, in this specific case, the Ironmongers Wages Board had the authority to determine or fix the wages of the ironmongers industry. And what it did was that in the exercise of their power as authorized by a statute, they ended up making a determination as well as to the hours that people were allowed to work in the industry. And the High Court ruled that when the board exercises power, not just to fix the wages, but also to determine the hours of work that were permissible in the industry, then that exercise was actually ultra vires, because it was the exercise of a power for an improper or an unauthorized purpose, and therefore the exercise of such a power was illegal or invalid. Now, what's interesting is that this principle, as we know, as we clearly see, has a common law origin. In other words, it is a legal principle that has been enunciated by the courts and has become part of the law of the land. However, that same principle has in fact now been incorporated in Section 5(2)(c) of the Administrative Decisions Judicial Review Act of 1977 of the Commonwealth. And the provision provides that an order of review can be sought in respect of an exercise of power for a purpose other than a purpose for which the power is conferred. So the principle is now embodied both in as a common law principle as well in statutes, as well as in statutes, specifically the Administrative Decisions Judicial Review Act of 1977. Now, although it's quite easy to understand the idea that the exercise of a power should be according to the authorized purpose, we can sometimes end up confronting some problems, and that is because whether or not a power has actually been exercised for a purpose for which it was conferred is not always straightforward. And there are two instances when this legal issue arises. And the first one is when a statute actually fails to expressly and clearly state its purpose. So when you go through a statute and you will come across a lot of laws being passed by Parliament, oftentimes because the statute might contain a lot of provisions and it may consist of a number of pages, the statute sometimes fails to clearly indicate what the purpose is. And sometimes we will even see that there could be multiple purposes. And this is, again, an issue that we will take up in a short while. So that can lead a problem because then you don't know what exactly is the purpose that's being authorized by the statute. But the second problem, or the second issue that you will be confronted with, is when a decision fails to expressly and clearly state or indicate its purpose. So what if a decision has been actually handed down, but the decision did not expressly and clearly state or indicate its purpose? In that case, how then are you able to measure that decision against the purpose which has been articulated by a statute? So that leads to a problem, and we're going to look at those problems in a short while. Now, there is, however, a way by which we can determine what the rules should be when a statute fails to state its express purpose. And what we do is to have a recourse to techniques of statutory interpretation. And the rule is that in the event a statute fails to state its express purpose, using the rules of statutory interpretation, you can determine the implied purpose of the statute. So in other words, even a statute which does not expressly state its purpose, there is always an assumption that that statute was made for a particular purpose. So therefore, the purpose can be implied. The purpose for the statute can be implied. And the way to do that is by examining the title, or let's say, in the case of Ironmongers Wages Board, there could be a statute which says that the board, creation of the board concerning wages. So therefore, the purpose of the board's creation is about wages. So in other words, if it ends up regulating an industry, or if it talks about certain benefits that go beyond wages, then that chances are you go beyond the purpose of the statute, at least the implied purpose of the statute. You also look at the structure and the text of the statute, as well as the nature of the power that is exercised. And that is according to the High Court in the case of R versus Toohey, ex parte Northern Land Council. But again, as we will later on see, even an attempt to apply rules of statutory interpretation can often cause problems because of difficulties in trying to draw the scope and limits of the statutory purpose and the considerations that must be concerned. So we're going to look into this in a short while. Now, when a statute fails to state its express purpose, one of the main dangers in this instance is that the decision maker may have decided on the basis of an improper purpose, that is, one that is not authorized by a statute. It is possible that he could have considered irrelevant matters or considerations, or had ulterior or improper motives. So in that case, because the statute failed to state its express purpose, it becomes quite difficult to say whether the decision was actually a decision according to the express purpose of a statute for which that decision was permitted to be made. And the difficulty of determining whether a power has been exercised according to a statutory purpose for which it was concerned is even heightened. The problem becomes even greater when a statute supports multiple purposes. Now let's look at statutes that may have multiple purposes. What happens when a law does not specifically state the purpose for which a power is to be conferred? Relatedly, if a power conferred by a statute is very broad, such that it is not expressly qualified or conditioned in any way by a statute, would there be any limit to its exercise? Or could it be claimed that the statute would have given unfettered discretion or unfettered authority or power upon the decision maker? Because the point is, if the power that is conferred by a statute on a decision maker is actually unlimited or it is unfettered, then it might be possible for the decision maker to argue that its exercise is always according to a statutory purpose and hence is actually valid. Or the decision maker may even say that the statute actually authorizes the decision maker to determine what the purpose of the statute should be. So stated differently, an argument could be made that when a statute fails to make its purpose specific, the purpose for which a power is to be exercised, if the statute fails to make it specific, then the exercise of such a power would have a semblance of propriety. And it would then be clothed with a presumption of regularity, and hence it cannot be impugned. Therefore, it would have been asserted that the exercise of that power would have been legal. Now, what are the rules that have been established by the courts? The rule says that it's difficult to speak of an unfettered discretion because even when the law is silent as to its purpose, there will always be ways by which the scope of the exercise of that authority is actually limited. And one of the cases is that decided by the Federal Court, the full court of the Federal Court of Australia in Shiliski versus Minister of Immigration and Ethnic Affairs, where the full court of the federal court said that even when the authority so conferred is not expressly qualified or conditioned in any way, like all statutory discretions, however, it is to be exercised in accordance with the scope and purposes of the enactment, which is its source. So even when there is an attempt to claim that a discretion is unfettered or unlimited, that will not be a good argument to be made because the rule still is that exercise of power or the exercise of that discretion will still have to be exercised or tested according to the scope and purposes of the enactment, which actually is the legal source of that power or authority. In the case of our two-haver ex parte Northern Land Council, the High Court, per Chief Justice Gibbs, also said, if a statutory power is granted to the Crown for one purpose, it is clear that it is not lawfully exercised if it is used for another. So the courts then have the power and duty to ensure that statutory powers are exercised only in accordance with law. The same conclusion was arrived by Justice Stephen, who said, if it be shown that a regulation made under that power was made for a purpose wholly alien to the Planning Act, it will be ultra vires the power and will be so treated by the courts. So even when a statute passed by Parliament authorizes an executive decision maker to pass subordinate legislation in implementation of a statute, such a subordinate legislation, such as a regulation, has to be drafted or written according to the purpose for which the statute was passed in the first place. Otherwise, the regulation would be ultra vires the power and would be invalid. So clearly, in the case of Shiliski versus Minister for Immigration and Ethnic Affairs, as well as R versus Tui, ex parte Northern Land Council, the jurisprudence tells us that when a law does not specifically state that the purpose for which a power is to be exercised, it doesn't mean that the power conferred by that law is unlimited and qualified. The rule is the power would still be limited and qualified by the purpose which is then inferred or implied from the statute, as well as the nature and extent of the power that is to be exercised. So, consequently, the exercise of that power can be tested according to the inferred or implied purpose of the statute, as well as the nature and extent of the power to be exercised. Now, what if when an executive decision maker makes a decision, there is actually an ulterior motive? So, in other words, perhaps on the one hand, there is the exercise of the power or the decision is authorized by the statutory purpose. But on the other hand, apart from having a decision that is authorized by statute, there is actually an ulterior purpose or an improper purpose behind the statute, behind the decision. In the case, for example, of Submarine Proprietary Limited versus Metropolitan Water, Sewerage, and Drainage Board, the court was confronted with a situation where the board sought to purchase a land. And according to the purpose of the statute, which gave the board a power to acquire the land could be acquired for the purposes of the board in, let's say, providing offices for its employees. So that was the statutory purpose that was available. However, there was also a possible ulterior motive for the board's attempt to acquire a land, and that ulterior motive, it was claimed, was that it was hoping to enter into a joint venture agreement with another agency of the government, so that as a result of the joint venture, as an investment on the property, the board stood to benefit from such an arrangement. And so, in other words, it is often possible to come across a situation where a decision both has both has a purpose which is authorized by a statute, but at the same time, it may actually have other purposes, ostensible purposes, which do not comply with the purpose for which the statute actually authorized a body to make a decision. And in the case of Submarine Proprietary Limited versus Metropolitan Water, Sewerage, and Drainage Board, the High Court said that if the board is seeking to acquire the land for an ulterior purpose, there will be an ostensible but not a real exercise of the power granted by the Act. The attempted exercise of power will be vitiated even if the ulterior purpose was not the sole purpose of the acquisition. It will then be an abuse of the board's power if the ulterior purpose is a substantial purpose, in the sense that no attempt would have been made to acquire the land if it had not been desired to achieve the unauthorized purpose. So in this specific case, the court actually validated and agreed that the purpose of the board in trying to acquire the land was authorized by the statute, because the board was attempting to purchase the land in order to increase the office space for its employees. Now, the fact alone that there was actually another ulterior purpose, and that was to have a joint venture agreement with another government agency, could have vitiated the decision. However, that other ulterior purpose was not a substantial purpose, because the main or the substantial purpose for the purchase of the land was actually to make sure that there was more than enough space for the expansion needs of the board and have office spaces for its employees. So that was the main and substantial purpose. So as a result, the court noted that even if the potential commercial venture with another government agency had not been there, the board at any rate would have decided to acquire the land for its own needs. And for this reason, the court validated the purchase of that land as being authorized by the statute which created or empowered the board. Now, apart from that first rule that we mentioned about the rules of decision making, and so as we said, one of the rules is that a decision maker must make a decision or exercise its statutory power according to the purpose of a statute. The second rule is that in exercising a statutory power or in making a decision, the decision maker must not take into account irrelevant considerations. And this rule was expressed in the case of R versus Trebilco in the High Court, where Chief Justice Latham said that a court can intervene when a decision maker takes extraneous considerations into account. So these are considerations that are foreign to what are matters that is authorized by a statute. Now, this specific rule has now been enshrined as a ground of judicial review in the Administrative Decisions Judicial Review Act of 1977, which provides in Section 52A that an order of review can be sought in respect of taking an irrelevant consideration into account in the exercise of a power. So what is an irrelevant consideration? The case of Morpheors Incorporated Proprietary Limited versus Commonwealth gives us an idea of what an irrelevant consideration is. And Justice Stephen in the High Court said that an irrelevant consideration would include consideration extraneous to the power conferred and all corrupt or entirely personal and whimsical considerations or considerations which are unconnected with proper governmental administration. So let's say that in coming up with a decision, an executive decision maker takes into account, for example, the fact that you seem to have certain political beliefs, or he may end up having certain gender biases, or he may actually have met with you before and dislikes you as a person. Now, these are considerations which should be irrelevant to whatever decision he is to make. And if therefore a decision maker makes decisions along those lines which are not authorized by a statute, then in that case, the decision would have been vitiated and will be considered to be invalid. It can also work in the sense that a decision may actually be made to favor a person because the decision maker happens to belong to a certain organization to which an applicant also belongs to, or on the basis of a friendship with somebody who is an applicant in a specific administrative matter. Again, that will have to be an irrelevant consideration, and the consideration or the use of that irrelevant consideration will again vitiate a decision. In Roberts versus Happods, in the House of Lords, Lord Atkinson gave examples of what might constitute irrelevant considerations in the determination by a local council of the salaries and wages of local council employees under a UK statute. And Lord Atkinson said that some of those irrelevant considerations would be some eccentric principles of socialistic philanthropy, or by a feminist ambition to secure the equality of the sexes in the matter of wages in the world of labor. And we can also provide other examples in other cases, such as using religion as a consideration in making a decision, or the fact that a person is good looking, or the fact that a person doesn't look good. So those are irrelevant considerations, or the fact that a person may have belonged to you might have joined the military, and if that is a consideration that is not authorized by a statute, then that consideration cannot be taken into account as well. Now, what is the effect of having an irrelevant consideration in the decision of the decision maker? Does it mean that every time a decision actually includes an irrelevant consideration, the decision will necessarily have to be vitiated and therefore invalid? And the High Court, in the case of Klein versus Domus Proprietary Limited and Minister for Aboriginal Affairs versus Pecco Walson, pointed out that taking account of an irrelevant consideration does not necessarily vitiate or invalidate a decision. For a decision to be vitiated, the irrelevant consideration must be the dominating actuating reason for the decision. In that same case, Chief Justice Dixon with Justices McTiernan and Windeyer also concurred, saying that if it appears that the dominating actuating reason for the decision is outside the scope of the purpose of the enactment, that vitiates the supposed exercise of the discretion. So in other words, the mere fact that a decision may somehow be tainted by the fact that an irrelevant consideration seems to have been taken into account, that fact alone will not mean that the decision is necessarily invalid. The only time that that decision will be considered valid if the irrelevant consideration was actually the dominating actuating reason for the decision. But if the dominating or actuating reason was actually authorized by a statute, the mere fact, in other words, that there seems to have been an irrelevant consideration that was taken into account, will not mean that the decision is necessarily invalid. It will only be when the irrelevant consideration is the dominating or actuating reason for the decision that a decision will be invalidated. As pointed out in the case of Australian Conservation Foundation versus Forestry Commission by Justice Burchett in the federal court, it was said that it is true that a decision maker may not take account of an irrelevant consideration, but I think he may pick up a red herring, turn it over and examine it, and then put it down so long as he does not allow it to affect his decision. So in other words, it is quite likely that when a decision maker tries to arrive at a decision, he is likely in trying to come up with a good decision. It is like that he may consider some irrelevant considerations. He'll think about it. But the mere fact alone that the decision maker may think about an irrelevant consideration will not necessarily invalidate a decision for as long as that irrelevant consideration is not a dominating or actuating reason for the decision. Now, there is a third rule that a decision maker must follow in arriving at a decision. We've already said two. The first one was that a decision of the decision maker must always be made according to the statutory purpose, whether the purpose of the statute is expressed or is implied according to the rules of statutory construction. And the second one is that a decision or the exercise of a statutory power must not take into account irrelevant considerations. But the third rule that a decision maker must observe in making a decision is that he must take relevant matters into account. And a failure by a decision maker to observe this rule may invalidate a decision. Now, this specific rule is now embodied as a ground of judicial review in the Administrative Decisions Judicial Review Act of 1977. Section 5.2b of the Act says that an order of review can be sought in respect of failing to take irrelevant consideration into account in the exercise of a power. Now, let's clarify what this rule actually means. The duty of a decision maker to take account of relevant matters only arises when it is required expressly or impliedly by a statute. So in other words, only when a statute expressly or impliedly says that these are relevant matters that should be considered can it be said that a decision maker must turn his attention or have a duty to consider those relevant matters into account. In the absence of such a statutory requirement, a decision maker is not required to consider certain matters. They only become relevant when so required by a statute, either expressly or impliedly. So in other words, a decision maker does not have an obligation or duty to consider every relevant fact or matter. In the case of Shawn Investments Proprietary Limited versus McKellar, Justice Dean observed that a party has no right to make an exhaustive list of all the matters which the decision maker might conceivably regard as relevant, and then attack the decision on the ground that a particular one of them was not specifically taken into account. In Minister for Aboriginal Affairs versus Pecco Wolfson Limited, Justice Mason then also said that not every consideration that a decision maker is bound to take into account, but fails to take into account, will justify the court setting aside the impugned decision and ordering that the discretion be re-exercised according to law, because a factor might be so insignificant that the failure to take into account could not have materially affected the decision. So in other words, for this rule to apply and to lead to the invalidation of a decision, the relevant matter that may not have been considered by a decision maker should be such as to possibly materially affect the decision that was made. Because otherwise, if it would not have a material effect because it is really insignificant, then the decision would continue to be considered valid and not be vitiated by the failure to consider irrelevant matter. So in other words, irrelevant matter that has not been considered by a decision maker, for that failure to invalidate a decision must be one that is significant and one that could materially affect the decision. So in other words, irrelevant matter that is insignificant and could not have materially affected the outcome of the decision would not necessarily lead to the invalidation of a decision. So after studying this topic, you should now be able to discuss and explain the three key rules that a decision maker must observe in making a decision or in exercising a statutory power. The first one being that a decision maker must exercise a statutory power according to the purpose for which it was conferred. Secondly, in exercising a statutory power, a decision maker must not take into account irrelevant considerations. And thirdly, in exercising a statutory power, a decision maker must take relevant matters into account.